All right, we'll get started in a moment. Let me turn the attendance on. Okay, 1 second, let me get the attendance going. Okay, the attendance is starting. Please sign in. All right, so here we are, November 9th. The semester, believe it or not, is almost over. This is sort of like the semester that never started that's almost done, right? We feel like this never even happened, but we are almost at the end point. At this point, I've met with almost all of you over the weekend sessions. I find these very helpful. I actually, I know you don't believe me, but I very much enjoy them. I think you're all, you have a lot of interests. You have a lot of, different life experiences. And I learn a lot from you all, and I enjoy it. It's a lot of work. I mean, it's not fun to sit in front of a computer for 5 hours straight, but I do enjoy it. So I thank you for that. Literal tears about finals. Oh, Macy, don't cry. We'll get there. We'll get there. I just want to make a note about attendance. I've noticed in this class and in other classes, people sign into the attendance, but they magically disappear when they're called on. It's happened not just here, it's happened elsewhere. Now, there might be some technical reasons why it happens. I don't care at this point. So if I call on you and you're marked present and you don't appear, I'll mark you absent. If you had a technical reason, you can email me, I'll take it off. But I don't want to do this game where I call on 3 people in a row and no one's here. That's not fun. And it's not fair to those who are actually taking care to prepare for class and actually do their homework. So that's the remedy. If you're not here, I'll just mark you absent, and you can email me later. I can fix it after class, and that's fine. Well, I don't want to waste time on this because it's not worth it. I don't have enough time to waste. All right. Questions about anything we covered last week in class? We talked about Brown. We talked about Bowling v. Sharp. We talked about the Cooper against Aaron case. Questions? All right, let's try a poll question. I don't think I asked this one last week. Oh, I'm sorry. Last week, the iClicker got completely messed up. I wasn't able to run any polls. I apologize. Just, I don't know what happened, but just something, it got into a very strange loop where I couldn't start a session. So I have no data from last week. I have your attendance from last week. I just don't have your poll questions. So let's try question number 1 and let's see where this goes. Resume. Okay, so this is question number 1. And I'll put the link to the chat for the class notes. So your question is Brown v. Board of Education consistent with footnote 4 of Caroline Products? Is Brown v. Board of Education consistent with footnote 4 of Caroline Products? That's what you guys have to say. And let's see. Whoever's next on the attendance, just please raise your hand. I'll call on you in a few seconds. All right. Are there 5 more seconds? Get people to put your answers in. All right, Aaron. I think you are next. You wanna help us out here? Where'd you go? There you are. I think you are on mute. Yeah, for whatever reason, when people have their headsets plugged in, it never actually works right the first go. That's fine.
Sorry. I said yes because Brown versus Board of Education deals with racial minorities, and so paragraph 3, I think, of
Very good.
But 4 talks about that, so that's why I said yes.
All right, so let me just share my screen just for a moment. I don't like doing that, but I think it'll be helpful here. I have the text of footnote 4 on my screen. And again, footnote 4 wasn't, a holding of constitutional law, right? It wasn't an actual statement of common law. It wasn't even a holding. There weren't 5 votes for it. But it identified a theory of constitutionality of when the presumption of constitutionality will not apply. Okay, so we have these 3 sort of, I call them off-ramps, right? Where you don't apply this presumption of constitutionality. In the first paragraph of footnote 4, we don't apply it where there's some specific provision of the Bill of Rights, which is not really relevant to Brown. You have the second paragraph, right? Where you don't apply footnote 4, where you have this sort of restriction on the political process. Then we get to this third paragraph, right? Where it says when you have laws that are directed at the so-called discrete and insular minorities, then the presumption of constitutionality is not applicable. And I think Aaron's right. I think the best way of reading footnote 4 is that in a case where you have literally school segregation, when you have school segregation, you fall within this paragraph, and then the courts need not presume that the law is constitutional. Now, that was Aaron. Who's next? James, you here?
Yes, sir.
So, James, when the presumption of constitutionality does not apply, who bears the burden of proof, right? Who has the burden to defend the law?
The state or whoever enacted the statute.
Good. So in Brown, who had the burden of proof? Who had to defend the law, segregation law?
Well, in theory, the state would have to defend that segregation law.
But you said in theory. What do you mean theory?
It's that I can't remember exactly if they were the ones who were defending that law.
Oh, I guess we've got some tunes in the background. Well, let me ask you the question a little bit differently. Jumping to a reading today in Loving against Virginia, the interracial marriage case, who had the burden of proof? Was it the Lovings, the couple, or was it the government of Virginia?
No, the government of Virginia.
Okay. So I think in both cases, in both Brown and Loving, which we have for our reading for today, the burden belonged to the government. And this is very important, right? What footnote 4 does is it gets you to have this presumption of constitutionality. And once you're outside this presumption of constitutionality, you can assign the burden to the government. And the burden belongs to the government to say, why are you entering into this law that that's directed at these religious minorities, or directed at these racial minorities, or directed at these discrete minorities, right? And the government says, well, we're doing this to promote, white superiority, right? Well, that's not a good reason, right? We're doing this to prevent white students and black students from interacting. Well, that's not a very good reason, right? But what's going on here, just to be very clear, is the court saying that this is not a wise law. Right, this is not a good idea. We think this is a bad judgment. This is racist. This is white supremacist. Whatever word you want to use in Loving, right? This is a bad law. And invariably, we go back to the sort of mode of judging the New Deal court hated. Right? Now, perhaps it's justified here because racial discrimination is such an evil, right? It's this unique evil. But at the time Brown was decided, it was not well received among law professors. I'm not talking about the South. They hated it. They wanted to impeach Earl Warren, right? Among law professors, this was considered a very bad idea. And the reason why was because they thought this is like Lochner, right? Many law professors, these were liberals, these were New Dealers, right? These were not conservatives. Many law professors saw the Brown case as a return to Lochnerism, that the court would start deciding what the wisdom of legislation. And even though this reached a result that was, popular, right? You integrate the schools. There was a fear that this would break open the footnote 4 too far. right? Footnote 4 was it 1938? And Brown was, 1954? So almost, 15 years passed between Caroline Products and Brown. No one, when Caroline Products was written, no one suggested this would mean interracial schools were unconstitutional, right? That wasn't even a thought. Indeed, Brown didn't even cite footnote 4. Did anyone notice that? Isn't that strange? That you have an actual Supreme Court opinion saying when you have prejudice against racial minorities, you have a more searching inquiry. Wouldn't it have been smart to cite footnote 4? I mean, Aaron and James, I think, are correct. Why do you think the court did not even include a single citation to Caroline Products? They didn't want to touch it. They realized that once you start using footnote 4, you're breaking apart this presumption of constitutionality, and you went back to Lochnerism. There was such a fear of Lochner, my God, this poor baker in upstate New York, that they didn't even want to touch footnote 4, right? It was just sort of this footnote. It was a dicta. No one even cared about it. Let's make our decision based on social science, but let's not disturb this constitutional settlement. When I say constitutional settlement, I mean the New Deal is like 37. We're settling this. We are not doing Lochnerism anymore. We're going to defer to the elected branches. We're going to maybe identify places where we don't defer, but we're not going to talk about that, right? The first rule of Fight Club, you don't talk about Fight Club. We don't talk about footnote 4. We just don't talk about it. I recently rewatched that movie, the Fight Club. It's a disturbing movie. I haven't watched it in 20 years, but it was good. Everyone with me? All right, so it's significant, I think, that the answer to question number 1, I think is true. I think footnote 4 is consistent with Brown. I think they are. I think they're consistent. But then you ask yourself, why is Brown not even cited in Caroline Products? Why do they cite it? It seems such an easy citation to make. I think the reason why it's not cited is to avoid even hinting at Lochnerism. That was just the fear. Okay. Everyone get that? Any questions on that? We will keep coming back to Lochner and footnote 4 for the rest of the semester. I mean, those are probably two of the most important decisions of the 20th century. Not very important at the time, but they would sort of take on a life of their own. Footnote 4 of Caroline Products and Lochner just are so essential, right? No matter what decade you're in, the justices think about footnote 4 and think about Lochner. No matter what decade you're in, no matter what court you're in, I don't care. That's always in their heads. It's amazing the staying power of those two cases. It truly is. Right? When we read the gay marriage decision, there'll be citations to both Lochner and Caroline Products. Right? In a decision of a modern, immense importance, it's still citing these cases from 100 years ago. All right, let's skip question 2. Let's do question 3. Okay, this is question 3. Multiple choice. Here's your question. When a law imposes a suspect classification, who has the burden of proof? All right, I think next is, I just called on James. I think, is that Bianca? Bianca, you next?
Yes, I'm next.
Oh, someone just asked in the chat, what's a proper way to cite footnote 4? Is it quotation? You just say footnote 4. It's almost like, like Prince. Everyone knows what it is, right? You don't have to, everyone, or Madonna, it's one name. Everyone knows who that is. Or, it's one of these well-established things. All right, Bianca. So let me ask you, what's your answer to this question, the poll question I put up?
I put the government.
Okay. How do you know that?
Because for suspect cases,
what does suspect mean? Let's maybe take some terminology, Bianca. What does suspect mean? What does suspect mean?
What does suspect mean?
Yeah. Just in common, yeah, in common discussion, right? When would you use the word suspect?
When something is being questioned.
Good. And why would something be questioned?
Because it's suspect.
It sounds sus. Yeah. Thank you, Shawnee. I appreciate that. What does the word suspect sound like? Right? Why might you suspect someone?
Because they're suspicious.
That's it. Very good, Bianca. Thank you. I was trying to play a game like a candygram. I draw it out of you, right? Right? When you use the word suspect, I want you to think of suspicious, right? When the government imposes a suspect classification, it's suspicious, right? So, Bianca, what's an example of a suspect classification?
Race.
Okay. Why is it suspicious or suspect when the government classifies people on the basis of their race?
Because it's suggesting that the government is trying to maintain white supremacy.
Okay. Now, does the government usually come out and say that's their reasoning?
No.
No, they did in Loving. We'll get to that case a little bit later. That's sort of like the last time they tried that, because that didn't work too well for them, right? But usually the government will try and defend it. How, Bianca? The racial classification. Think of Korematsu, for example.
Oh, that like public safety, a threat to public safety, or
good. Okay, all right. And so you said you put B here, the government.
I'm sorry.
You put B, the government here. That was your answer.
Yes.
Okay. All right. Very good. That's correct. Okay. Last class, we began to discuss different types of classifications, right? When we're dealing with the Equal Protection Clause, we have to ask ourselves, what basis is the government classifying people on? Are they classifying people on the basis of their race? Maybe on the basis of their sex? Or maybe on the basis of their age? Age. Let's try question number 4, everyone, on the poll. Okay. Here's your question. Question number 4. State A allows 16-year-olds to apply for a driver's license. I think Texas is 16, I think. State B allows 18-year-olds to apply for a driver's license. I grew up in New York. When I was in New York, I think it was 17. I think now it's actually 18. Apply for a driver's license. Does State B violate the Equal Protection Clause? Okay, another 10 seconds. I think Seth is up next. Is it 16 in New York now? Okay, well, I got mine at 17. Oh, also, it's New York City. I think there might have been a different rule then. I also failed my road test twice. The only test I ever failed in my life. Sure. My first road test was bad. I took it in Brooklyn, which was a mistake. I don't know why I did that. And at the very beginning, as I was pulling out, the very first minute, I hit the car in front of me and I pulled out the park spot. He let me finish. I don't know. I don't even know why he let me finish. He's like, just go do it for practice. And I failed. The second time I'd actually finished it, I was about to pass. He was already writing up the pass slip. And at the very last minute, I got excited. I blew a stop sign at the very last minute as we were pulling back into this. Oh, man. Third time, I think they took pity on me. The road test, yeah. Only test ever failed. All right, Seth. Does State B, we'll just call it New York here to make our life easier. Seth, does State B violate legal protection clause here?
I don't think so.
Okay, tell me why.
Well, if they're not depriving a liberty,
But they're classifying people. They classify people on the basis of age. Isn't that suspicious?
well, I think, doesn't that have to do with the state police power?
So what? Isn't it suspicious to classify people by the basis of their age? If Texas allows you at 16, why does New York make it 18? What's New York trying to hide? What are they really accomplishing? You know, like kids?
Maybe. That's just, I mean, isn't that what the whole reason the burden lies with the government, though? Is because they might have their own reasoning as to why a certain law was passed in their state as compared to others.
Yeah, but if Texas can do it at 16, why New York at 18? What's so special about New York?
I don't know.
But answer before we get to the burden, we'll get to the burden in a minute.
Okay.
Is it suspicious? Should we be suspect that New York is denying licenses to 16-year-olds? Is that suspicious?
I mean, a little bit, but driving isn't. Well, I don't know. Is that really a license? Isn't really a constitutionally protected right?
Oh, is that the line you want to use? Is going to school a constitutional right? Oh boy! You walked into that one. I'm sorry. I didn't mean to buzzsaw you, but you walked right into it. Seth, let's start with the simpler question, right? Is it suspicious to deny licenses to 17-year-olds?
Yes.
All right. Let me try to. Who's next? Smiha, you here?
I am here.
Okay. Let me change the hypothetical a bit, right? Let's say the law is different, right? Let's say that girls can get their licenses at 16, but boys get them at 18. Is that suspicious?
That is suspicious. However, at the end, the right to drive is still being protected, which is what I feel is important when we look at the due process clause. Like, or the equal protection clause? It's protecting your right to drive. It's just changing when you have the ability to start driving.
Should we?
There might be.
I'm sorry to interrupt. Should we be very skeptical when the government is denying 16-year-old guys the right to drive, but they're giving it to the girls at 16? Should that make us very skeptical? Why is the government doing that?
No, because there could be a valid reason for it.
What might the valid reason be?
Men are terrible at driving at the age of 16, or they're more likely to be irresponsible or get into accidents.
You're not wrong. You're not wrong. If you look at insurance premiums, right, and if you look at statistics, teenage girls tend to be safer drivers than teenage boys. I can give you line and verse. Fake news. Thanks, Raymond. Right? No, it's true. It's true. Look now. Smiha gives this question, so let me call on who's next? Douglas, let me just change the hypo once more, right? Let's say that the state does a very detailed survey of car accidents and race, and it finds that certain races are better drivers than other races. And, this is objective, but just some races, people of one race tend to be safer drivers than other races. Can the government say, okay, if you're 16 and you're in this race, you get a license, but if you're in this other race, you get 18, you get your license?
Well,
is that okay?
The underlying basis is based off of race, and race is inherently suspect.
But that's the point, though, right? I forget suspect for a minute, right? Let's say you do a very detailed study, a very detailed empirical study with all the drivers in the state, and they find that people of one race are statistically more significant to get into car accidents as teenagers, and people of the other race are less likely to get into car accidents as teenagers. Could the state say, okay, if you're in this race, you get your license at 16, and you're from this race, get your license at 18. Could you do that? That's similar to the question you gave to Smiha a minute ago with gender.
I mean, under strict scrutiny of it, I guess that would essentially...
Forget strict scrutiny for a minute, right? Is that... Forget doctrine, right? Just in the abstract. Is there a difference between guys and girls getting their licenses versus black and white people getting their licenses at different ages? There's some difference. In other words, Samiha said without any hesitation that girls are safer drivers than guys, right? And there are numbers to prove it. Is there a difference between, let's say, the similar numbers? Let's say one race is safer drivers than another race. Could you draw a classification on that basis? Is it different than gender?
If the evidence supports exactly what Congress is trying to stop.
So if the evidence is there, you can do it. Samiha, I saw your hand pop up for a second and went back down. Did you want to add something?
I was going to say that when you start getting into race and start dividing people by race, the conversation, I think, changes because race has been such an issue in the past. I mean, gender is also an issue, but race has been significantly more to where people have been stopped from being able to do things because of their gender. So I think that's the other thing that you have to pay attention to, especially with the United States and the history of the United States.
I just want to hear you. So you said race and gender are different, but is that was your
Yes.
race? So race is different. Okay. So if we had to Samia, let me, if I can ask you a follow-up, because I think you made a good point. If we had to just sort of rank levels of suspiciousness, right? So we have age and we have gender and we have race, right? Is that with age, we very suspicious?
No.
With gender, we suspicious?
A little bit.
And race? Oh, okay. You guys just figured out the tiers of scrutiny. Good job. No, it was actually very good. I didn't plan that. It actually felt very naturally, which I was happy to do. The Supreme Court, over the course of, half a century, have created a framework to understand the Equal Protection Clause. And they've carved out what are often called the tiers of scrutiny. Oh, sorry, the tiers of scrutiny. Okay. Let me type this out on the chat just so you can see it, because here the words do matter of how you phrase these, right? So let's just start with the three classifications I gave to Smiha a minute ago, right? So you have age, sex, and race, right? These are these three, and I picked these not entirely at random, but these are the three I picked that are easy enough to explain. All right? Race is considered unique. We say race is a suspect classification. Okay? And when I say suspect, what I really mean is suspicious, right? When the government comes to us and says, we want to classify people on the basis of race, we're like, okay, wait a minute, hold on here. Are you really doing this because of statistics or because you're racist, right? How do we know that this is based on some legitimate interest versus how do we know this because you don't like black people or Chinese people or Japanese people, whatever happens to be, right? Even if the government has this very detailed study showing that black drivers are less safe, whatever, it's like, wait a minute. Okay. And then you have age. We call age a non-suspect classification. I can't spell. A non-suspect classification. It's basically the opposite of suspect, right? It's like, look, everyone's a kid. Everyone grows up. We impose disabilities on minors. What's the big deal, right? If you're a minor, you can't sign a contract. You can't get married. You're not going to be liable for certain torts, right? You know the rules, right? If you're a minor, you're treated as basically you're incapacitated. You lack capacity to do anything. But God willing, we all grow up, right? We start as kids and we grow up, we become adults. And then whatever burdens are imposed upon you will eventually fade away. So, poor Josh can't drive in New York till he's 18. Okay, whatever, he'll be 18 eventually, God willing. All right, to become 18, right? So the age classifications are non-suspect. Not suspicious at all. So what do we do with sex? I think Samia, accurately articulated that sex was kind of somewhere in between, right? Maybe it might make sense to let girls drive younger because they're safer, but we wouldn't let that happen to race, right? So it seems, at least historically, that society is willing to tolerate more restrictions on sex. Now, the example I would always give in the past was bathrooms, and that example may be out the window now. Thank you, Justice Gorsuch, right? He had a decision where Gorsuch said that sex and sexual orientation and gender identity are one and the same. So that's now our new world. But at least historically, sex was somewhere between. It was called quasi-suspect classification. Okay, what does this word quasi mean? Like partially? It's like maybe suspect, maybe it's not. This is not a clear standard. And I don't want you to think these are like, tiers or layers of a cake where they're very isolated. They blend together. But with any equal protection question, your first issue, right, the first thing you have to do in your head is classify the government's action, right? How is the government acting? Yeah, Doug, go ahead. Douglas, are your hands up?
Yeah, sorry. So then, do these levels that you're currently putting right now, do they relate to the different levels of scrutiny?
That's my very next point. You jumped at 30 seconds. Okay, remove spotlight. Back to Josh. Okay, so the reason why it's important to classify these three layers, these three tiers, is the tiers tell you what kind of scrutiny you're dealing with, right? Again, when I say scrutiny means how stringently are you reviewing the law, right? Or how deferentially are you reviewing the law? So the first one we can talk about is race. And with race, we have a suspect classification and we follow strict scrutiny. Right? We follow what's called strict scrutiny. With strict scrutiny, the most important feature is the burden, right? The burden. Who has the burden? The burden is on the government, right? The government has the burden to show and defend their law, right? This is, if you want to think of it, the Lochner approach, right? Where the government has a burden to defend their law. It's what you might call the presumption of liberty, right? The government has a burden to defend their law, and the presumption is one of liberty, that the government cannot act. Come with me. Let's jump back to number one. What if we're dealing with age? You get a license at 16 or 17 or 18. These are non-suspect classifications, so we apply what's known as rational basis review. Okay? Rational basis scrutiny. The rational basis scrutiny is going to either be the Lochner dissents, right? Why? Because the burden is on the challenger, right? The person challenging the government law has the burden of proof. And with rational basis review, the law is presumed constitutional. There is a presumption of constitutionality. Everyone with me? Okay. Everyone with me? All right. So far, we've distinguished between rational basis review and strict scrutiny. Until the 1970s, that's all you had. You had these two tiers. You had rational basis and you had strict scrutiny. But starting in the 1970s, the court created this middle tier, what's known as intermediate scrutiny. We will cover that, I think, a week from today, so we're not going to get there quite yet. But you should know with intermediate scrutiny, the burden is still on the government. And there's a presumption of liberty applied. Now, someone's going to raise their hand and say, Josh, what's the difference between number 2 and number 3? Right? What's the difference between intermediate scrutiny and strict scrutiny? The answer is not much. They're very similar. There's not much of a difference, and we'll explain that later. So for your purposes, know that number 2 and number 3 are pretty similar. All right. Everyone with me so far? Questions so far? I'm not done yet with this document. We'll come back to it in a minute. All right. Let's continue. All right. Now I want to give you the tests that are used for each of these. All right. It's easy enough to memorize the tests, but it's far more important to understand them. So I'm going to type it out, and then I'm going to read it. Okay. I'm actually going to copy and paste it. That way I get it correct for my notes. Okay. The test used for strict scrutiny is as follows. The government policy, known as the means, is narrowly tailored, that's called the fit, to serve a compelling governmental interest. That's called the ends. Again, the government policy, the means, is narrowly tailored, that's the fit, to serve a compelling governmental interest. Those are the ends. This approach is known as means end scrutiny. The court looks at, number 1, what is the government doing, right? What is their classification, right? What are they doing? Okay, they're telling Japanese people they have to go live in these camps, or they're telling black students they have to go to these special schools, right? That's the policy, that's the means. Okay, they ask, what is the government trying to accomplish with this racial classification? Oh, they're trying to make national security, they're trying to keep races peacefully apart, right? Whatever their policy is. Okay. Then we ask, what is the fit between the means and the ends? In other words, how closely related is the government policy to what they're trying to achieve? And I can use an analogy that may help make sense. We can go dress shopping, we can go clothes shopping, and you can buy a suit, right? You can go to, Walmart and buy a very cheap suit that sort of just hangs off you and doesn't really fit you, right? Does it do the job? Sure, it's a suit, but it's not narrowly tailored. It doesn't really fit you well, right? It kind of just hangs off you. Or you can go to an Italian dress shop and they make a custom suit for you and it fits you perfectly to the inch, right? It's very narrowly tailored, right? There's no excess baggy fabric, right? It is only the amount of fabric needed to get you to goal of looking, fresh to death, right? You look good. Think of scrutiny in a similar fashion. Everyone agrees that using racial classification is a bad idea. You shouldn't do it. So you try to use race as little as humanly possible, right? You don't use it any more than you need to, right? You don't have any excess fabric, right? You're only using as little as you need to. So when you have a policy that imposes a racial classification, you ask yourself, do you really need to use race here? Or maybe you could use something else, right? Maybe there's some other way to accomplish your goal. So the government has to show that we're using race in the least amount possible. We can't accomplish our goal without using race in just a little bit. And look, we're using race for a good reason. We're trying to achieve a government interest that's compelling, a very important governmental interest. Right? So I'll use an example from the affirmative action reading for today, right? The government uses a racial classification. Generally, a racial classification is not allowed. But they say we are using race in a very limited way to achieve diversity, to achieve benefits that flow from diversity. A quota is not allowed, right? A quota is using race in too broad of a fashion. But if you have just the Harvard model that's discussed, well, that's okay. So what you see with these cases is this sort of means and scrutiny, right? How much are you using race, and can you accomplish your goal without using race? Or we can, maybe accomplish this a different way. Maybe make admissions based on income, right? Maybe make income based on family history, right? Have other circumstances other than race, right? Can you achieve the same diversity without using this racial preference in this fashion? That's what's being asked. Okay. Questions on the strict scrutiny standard? I don't believe you. I know you don't get this. It's fine if you don't, but this is not easy. I don't pretend it is. Students will memorize narrowly tailored, serve, compelling, but they don't understand what it means, right? Each component has a meaning, right? What does narrowly tailored mean? Are you using race as little as possible? Is it, are you in a Walmart suit or are you in an Italian custom suit, right? Which is draping off your body, just sort of hanging, and which is like perfectly fit for every single inch of your body. And is your interest compelling, right? If you're trying to achieve, just some sort of boring interest, that's not enough. It's got to be really important. The upshot of strict scrutiny is that once you get to strict scrutiny, the government loses. Not always. They win occasionally. But the general rule, at least in the last half century, is that racial classifications are presumptively unconstitutional. Right? Racial classifications are presumptively unconstitutional. Okay, questions so far? Someone asked, is race the only classification that's suspect? Race and nationality are. Don't ask me to explain the difference between race and nationality. I'll screw it up, but race and nationality are different. Religion is also considered a suspect classification, which might sound, sort of strange because isn't there a free exercise clause? And indeed, it's very rarely going to be the case where you have a religious free exercise clause. Religious equal protection case. It doesn't come up much. So the short answer is it's basically race and nationality, and invariably nationality is subsumed under race. It's sort of the broader umbrella. So it's pretty much just race. I mean, there might be others. For the longest time, there was discussion of whether sexual orientation might be a suspect classification, and whether gender might be a suspect classification. That hasn't happened yet. It might still happen. I'm not optimistic. I don't think it will. That's probably not going to happen. But at this point in the year 2020, the answer is race and pretty much nationality, but it's really just race. Okay. Let's go back to our chart. Where are we? Oops. Okay, so share screen. Hold on. Someone just wrote. Okay. And Tori, I see your hand in a second. Let me just do the question in the chat first. Someone wrote, who gets to decide what's compelling, right? Isn't that arbitrary, right? Can the government just say, well, that's not compelling enough? You see the footnote 4 dilemma, right? Once you abandon the presumption of constitutionality, you let the court decide what a compelling interest is. You let the court decide what narrowly tailoring is. And these are all judicial tests that are not easily reduced to any sort of clear statement. So the short answer is there is no good answer, right? This entire area, the courts are sort of on their own, feeling out for themselves what they think is right and wrong. Once you break away from footnote 4, you give judges a lot of discretion. And then you have to, I suppose, live with the results of how they use that discretion. Tori, go ahead.
This might be a dumb question, but my head is kind of whirling with like the application of this, and I think that I might be a little ahead of myself in what I'm about to ask. But with the ban on transgender people in the military, was that, I don't really know if that was ever like, I assume that it was challenged, but would that be an intermediate scrutiny standard?
So the short answer, and you are ahead of yourself by about 2 weeks. The short answer is that Justice Kennedy doesn't like scrutiny. That's a short answer. And in all the cases involving gay rights, he never once discussed what level of scrutiny a classification is on the basis of sexual orientation. The Supreme Court has not gotten to the gender identity issue yet, although Justice Gorsuch raised it in a statutory context, and he suggested that that sexual orientation, gender identity, and sex are all the same thing. There's no difference. So, in theory, at least, the answer is intermediate scrutiny. That's the short answer to your question. But Justice Kennedy never told us for sure. He just never cared about it. Oh, wait till you see guys make the Kennedy opinions. You're going to hate them. You're going to hate them. Trust me. Everyone always does. They love the outcome. They hate the reasoning. All right. Other questions?
Strict scrutiny applies to like political.
Who's speaking? Who's speaking?
My bad. Denver.
Yes. Just raise your hand, please. Go ahead.
Yeah. Sorry. Political speech applies to, strict scrutiny applies to like political speech too, doesn't it?
All right. So let me just. I didn't want to do this, but you asked, I will.
Sorry.
The phrase strict scrutiny means different things in different contexts. Ready, guys? There is strict scrutiny for the Equal Protection Clause. There is strict scrutiny for the Due Process Clause. There is strict scrutiny for the Free Speech Clause of the First Amendment, right? The same phrase, strict scrutiny, has different meanings in different contexts. If you take me in free speech, teaching free speech in the spring, we'll spend weeks discussing what strict scrutiny means for free speech. Right? The phrase intermediate scrutiny has one meaning for equal protection, another meaning for the First Amendment, free speech, and another meaning for the Second Amendment, right? These labels, strict, intermediate, rational basis, mean different things in different contexts. I do not want to clear that up yet. It'll confuse you more. So, Denver, I'm ignoring your question. Shawnee says, yes, it'll clear everything. No, it won't. First Amendment is a fun class, but it's complicated, right? If you think this stuff is mushy, wait till you get to free speech. It's even more mushy. You're going to miss the Commerce Clause. I love teaching the Commerce Clause. There's actually stuff for me to teach. There's doctrine. But everything else is just fluff, right? It's just whatever. People hate when I say that, but it's true. It's whatever, right? The second half of this class is, it's a lot harder to teach because it gives students difficulties. Just, is this a compelling interest? I don't know. How am I supposed to know if it's compelling, right? Is this narrowly tailored, right? So we're getting into the weeds, my friends. So it's a much harder class to teach. And I think also for your outline, the second half of the semester will be a lot harder for you guys to outline. Yeah, Macy, go ahead.
Does this connect with Korematsu talking about the strict scrutiny?
Yes. Okay. Korematsu, Macy, you're exactly right. Korematsu did not use the phrase strict scrutiny. I think they use the word rigid. You want to check your notes? I think it's the word rigid, if my memory serves.
It is rigid.
Yeah, thank you. Thank you for checking that. The concept of strict scrutiny did not come about to the 50s or the 60s, so it's later in time. Korematsu was, 43 or 44? But yeah, Korematsu is a unique case where the court upheld a racial classification. Right? Korematsu said, well, there's compelling interest here. National security. And the government's policy may not be ideal, but it's suited, right? It's adapted for achieving that interest. Now, was the detention policy in Korematsu narrowly tailored? I don't think it was. It basically applied to everyone without any regard to their individual history, right? Whether they were a spy or not. But at least in the 1940s, the court had developed the rigors, the sort of tests that you have in the Loving case we'll study today. Thank you, Macy.
Thank you.
Other questions? All right, let's go back to our chart if we can. So we have the standard for, right, we have the standard for strict scrutiny. Now let me give you the standard for rational basis. And again, this is more or less the Lochner dissent. I won't say Holmes or Harlan, but it's the Lochner dissent, right? So the rational basis test asks, the government policy, the means, must be rationally related to serve a legitimate governmental interest. The government policy of the means is rationally related, the fit, to serve a legitimate governmental interest, the ends. Okay, so what's going on there? I want you to contrast the test for the rational basis test with the test for strict scrutiny. So first off, the fit. With rational basis, you'll need a rational relationship. Whereas here you need narrow tailoring. What does rationally related mean? It's in the ballpark, right? If the state decides that 16-year-olds are too risky to drive and you really should be 18, that's good enough. They don't need evidence. They don't need statistics. All they need to show is that there's some relationship between what they've achieved, what they've enacted, and what they're trying to achieve. Right? There's some fit between restricting driving and highway safety. Right? Because that's the end. The end doesn't have to be compelling. It only needs to be legitimate. Is highway safety legitimate? Sure. Is it compelling? I don't know. Right? So here, a law restricting 16-year-olds driving would be perfectly constitutional. There's no doubt about it. It's an easy law to uphold. Because there's a rational relationship between restricting teenage driving and highway safety. It's actually an easy case to make. But again, you have in number 1, legitimate interest, and number 3, compelling interest, right? Compelling seems really, really high up, and legitimate, it's like, yeah, whatever. It's not garbage. It's an actual interest. You're not making it up. With the rational basis test, right? With the rational basis test, the government almost always wins. Not always. Occasionally, you can win rational basis review, but the government almost always wins. If you want to think about Williamson v. Lee Optical, right, the eyeglasses case, that is rational basis test in a nutshell, right? The Lee Optical case, right? Where really any classification is upheld so long as there's some conceivable basis in which to uphold it. That's how, in some cases, it's interpreted, and it's very hard for a challenger to actually prevail. Everyone with me? All right. Let me finish it up. We'll do sex discrimination, I think, next week. But here's the test for the second category. The government policy, the means, is substantially related, the fit, to serve an important governmental interest. The government policy, the means, is substantially related, the fit, to serve an important governmental interest. So what's going on here, right? The fit is leveled up a bit. It goes from rationally related to substantially related. It goes from rationally related to substantially related. What's the difference between rationally and substantially? I'm not really sure, but substantially sounds more, it's harder to satisfy. There's got to be more evidence, right? Maybe there's some evidence that women drivers are safer than male drivers. Is that enough? And the interest must not be merely legitimate, but important, right? So if legitimate's here and compelling's here, important's somewhere in the middle. It's like some sort of intermediary level of importance. All right? You're going to have to memorize these three categories. And not just memorize them, but understand how to apply them. And try to think in each case about the examples I gave. Right? Giving licenses to 16-year-olds versus 18-year-olds, giving licenses to men versus women, versus giving license to people of different races, right? If you try to keep those hypotheticals in mind, I think this chart will become a little bit easier. I think it will. And this, it's in the class notes. You can copy this later. But think very carefully about these issues because you'll need to know them cold. And actually be able to apply them. All right. Questions on these three standards of review, which we spent almost an hour and 20 minutes on, but that's about what I expected. Yeah, a lot of you complain, Josh, we have no time for cases. I know, it breaks my heart, but everything on Zoom takes longer. I need to just budget more time for everything. Even if they gave me back my 15 minutes, I still wouldn't have enough time. I'd still have to rush. So this is our world. I'm actually grateful in hindsight to have the video library with the 100 cases book. I didn't build it for, I didn't build it for COVID, but it came out just the right time. And we've sold, in the first year we sold 20,000 copies of that book. It was very, very successful, more than I expected. But I'm actually grateful I have it because I can sort of rely on it. I don't have to do a lot of the in-person stuff, which I don't have time for. All right, questions in these three tiers. All right. Let me mention briefly, just so your notes are clear. I'll go back to the screen sharing for just 2 more minutes, I promise. These are the 3 tiers for equal protection, right? These are the 3 tiers for the equal protection clause. We are also going to do the 3 tiers for the due process clause. And I only want to give this to you now so your notes are complete, right? So with the due process clause, we also have strict scrutiny, and we also have rational basis scrutiny. Okay? But with due process, we don't look at how laws are classified. we look at what types of rights are being burdened. I said again. With equal protection, we look at how are people being classified. With due process, we look at what rights are being burdened. So if there's a law that burdens a fundamental right, that law is reviewed with strict scrutiny. In the loving case, the marriage case we have for today, the court says that marriage is a fundamental right. And when you identify a so-called fundamental right, the law is reviewed with strict scrutiny. And again, when you have strict scrutiny, the burden is on the government, right? Virginia had to defend why they were denying licenses to the Lovings. Okay. We also have rational basis scrutiny for laws that burden non-fundamental rights. Isn't that original, Supreme Court? Yeah. You have fundamental rights and you have non-fundamental rights. Yes, Josh, what's the difference between a fundamental right and a non-fundamental right? Check back in about 2 weeks. We'll come back to this later this semester. There is a distinction. I don't want to do it now, but there's a distinction. And here the burden is on the challenger, as always. So you have this one in the middle, right? Wouldn't it be great if it was called intermediate scrutiny? Wouldn't that be fun? Yeah, no. We have something called the undue burden standard, which applies to one type of law. Laws that burden abortion. There's an entire category of the due process clause for abortion laws. That's it. It applies to nothing else, abortion. We will come back to it. So I want this entire picture to be here in your notes, top to bottom, right? So we have these 3 tiers for equal protection. And we have 3 tiers for due process. With equal protection, we're asking, how is the law classifying people? And with due process, we ask, what right is being burdened by the government, right? What's being burdened? There are different inquiries. Now, I'm going to tell you how I'd say half of you will screw up the exam, right? At least half of you will screw up the exam this way. You'll confuse them. I'll give you a question about equal protection and you'll use a due process framework. Or I'll give you a due process question and you use an equal protection framework. I'm telling you, half of you will do this. No matter how much warning I give you, you're still going to screw this up. Like, I'm not saying this to be mean. I'm just going based on history. I know how this stuff works, right? So don't let that be you. Be the other half, okay? When you read a question, I am not going to ask you, is this a violation of the Equal Protection Clause? I may just say, I'll be a jerk. Does this violate the 14th Amendment? Poof. You have to figure out which clause I'm talking about. And you have to decide, is this a law that's classifying people? Is it a law that's burdening specific rights? Or like in the Loving case, is it both? Right? In Loving, you had both an equal protection analysis and a due process analysis. So you need to be very attentive, the other half, right? You need to be very attentive of the facts I'm giving you and figure out if you're going to apply an equal protection framework or you're going to apply a due process framework. If you're going to apply a due process framework, you need to talk about fundamental versus non-fundamental rights. If you're going to apply an equal protection framework, you're going to apply a suspect classification or quasi-suspect or a non-suspect, right? I know right away if you get this by using the right terminology. If you're talking about equal protection and you say something about a fundamental right, I know you don't know what you're talking about. If I give you a question on equal protection, you're saying something about fundamental rights, you don't know what you're talking about. You have to be precise what you're doing. If it's both, you say both. All right? I'm making such a big fuss about this because people screw it up every semester, and you should be the other half, right? You can do it, right? Don't fall into the trap. And if you think it's being mean, Justice Kennedy never distinguished these. It drives me bonkers. He will not make any effort to separate equal protection and due process. For him, it's just sort of this double helix that wraps around itself. It's embarrassingly bad. I don't mean bad Supreme Court justice, but it's hard to teach, right? If Justice Kennedy was my class, I'd give him a bad grade, but he gets to write the laws. Thankfully not anymore. So someone asked, if the question is both, you apply both frameworks. Yeah, right. So if a case like the Loving case, where the court sort of suggests that the denial of equal protection is itself a violation of rights, you talk about both. But it won't always be that clear. Sometimes it'll be just one or the other. But you have to be attentive to it. And you can't expect me to tell you exactly what I'm looking for. I need to give you a little bit of space to run around in, and then you need to sort of pick up the pieces and figure where you need to go. Right? You'll know. If you know this material, you'll know what I'm asking. Right? It'll become obvious to you once you start getting into this, but I can pick an exam very quickly that doesn't know the difference. Right? Don't say fundamental rights with suspect classifications. That's probably wrong. Keep your terminology straight. Even if the Supreme Court doesn't keep it straight, you need to. All right. About 30 minutes left. All right. Questions so far? All right. Okay. All right. I don't know who's next. Is it Rachel? Rachel, you next? I think.
Yep, that's me.
Sorry, you've been just waiting like on deck for like an hour and a half. It must be just painful. I'm sorry.
It's okay.
Okay. Well, I appreciate that you're ready. All right. We only have 2 cases today. Actually, I think I told you I shortened the readings because this topic I think is so significant. I broke it apart. I usually cover Loving in the same class I do Brown, and I cover, when I do affirmative action, I do both the case from the 70s, the 90s, and the today. But here I broke into 3 classes because I couldn't do it all at once. You want to give the facts, please, Rachel, in the Loving case?
Yes. So in the Loving case, Mildred and Richard Loving were a married couple who lived in Virginia. Mildred was African American and Richard was white. Interracial marriage was illegal in Virginia, so they went to DC to get married, came back to Virginia, and were arrested shortly afterwards and criminally tried for violating the Virginia statute that outlawed interracial marriage.
Okay, very good. Now, just to make the point clear, what was a Loving case that came to the Supreme Court an appeal from their conviction? In other words, Rachel, how did this case get to the Supreme Court?
They were appealing their conviction from the state court.
How many years later?
Wasn't it about 5 years later when they filed the motion to set aside their conviction?
Okay. You just said it. So this wasn't a direct appeal; it was a motion to set aside a conviction, right?
Yes.
What does that mean? A motion to set aside a conviction. What does that mean? You know?
Would that be to? I mean, isn't that to overturn their conviction?
Okay. Well. Okay. Thank you, Rachel. Very good. You don't always learn this in 1L, so I'll give it to you a little history. Generally, when a person is convicted of a crime, they have the right of what's called direct appeal, right? You know, if they're convicted in a trial court, they can appeal to the state Supreme Court. And then they can appeal to the U.S. Supreme Court. The U.S. Supreme Court's under no obligation to take a case. After the U.S. Supreme Court denies review, the case is over, right? You have a final judgment, res judicata, as we say. But let's say some years later, when the person's already in prison or serving their sentence, they decide to challenge their conviction. There are certain ways of going to court and seeking to challenge an old conviction. You know, maybe there's new evidence, right? Maybe you found DNA. DNA didn't exist back then, but maybe you found some new evidence that proves you didn't commit the crime, right? Maybe there's some evidence that the jury was biased. Maybe it turns out that the judge took a bribe from the other party, right? So there's ways of challenging a conviction So the Lovings here were in a tough spot. I don't have time to play it for you, but there was a movie. Well, maybe I should. Nah, I don't have time. It's a really good scene. All right, I'm going to do it. I know I shouldn't, but I think it's an important scene to play. So there's a movie called Loving. It's a perfect name for the movie. It came out around 2-3 years ago. I want to play a short clip. It's about 3 minutes, but it's very good. I think it's worth your time. So the setup here is that the lawyer. Oh, he just died. Bernard Cohen. He died like a few weeks ago, actually. The lawyer for the Lovings is trying to help them to get their case going. And he's saying, okay, here's how we can bring your case back to court. I don't want to ruin the scene. It's a good scene. The movie I thought was, usually Supreme Court movies are terrible, but this one was I think a good Supreme Court movie. So let me just play this clip.
My clients are Mr. and Mrs. Loving. Could you send them down when they arrive?
Certainly.
Okay, so this is a lawyer for the Lovings. So the lawyer actually was an attorney in Virginia. Obviously, the Lovings couldn't visit him in Virginia, so they had to visit him in an office in D.C. because they couldn't even enter the Commonwealth. So what he does, he puts his own nameplate down. He changes the family photos.
Come in. Mrs. Loving, please have a seat. Bernard Cohen, it's a pleasure. Thank you for coming in today. So, as we discussed on the phone, the ACLU would like to take on your case. I was actually a charter member of the ACLU in Virginia, which is why they assigned me to you. The bottom line is, we want to get you all some relief.
That's very generous. Thank you.
Now, the first step is to appeal the sentence in Caroline County. That will be our fastest route to federal court. The problem...
Federal court?
Yes, the goal is to try to get the federal court to hear the case.
I don't understand the federal court.
I see it as the best route.
Can't you just go and speak to judges here?
That was a trial judge.
I don't think that...
Just talk to him. Just talk to him. Just tell him if you let us back in the state, we won't bother anybody.
Look, I do not think that this case will be resolved in Judge Bazio's court or probably any other court in the state of Virginia. I believe this is a court battle that could go all the way to the Supreme Court.
You're listening.
Our problem is that in order to appeal the judgment of conviction, we would have needed to do so within 60 days. Now, given that it's been 5 years since that conviction, we have to find a way to get it back into the courts.
Ready for this?
Are you following?
Ready for this?
Now, I've given this some thought, and I have a somewhat unorthodox idea on how to do this. My suggestion would be for the two of you to return to Caroline County, get rearrested, and then we'll have an avenue for our appeal.
You want us to get arrested again?
Yes, it's an idea. I, of course, will be there to bail you out.
God.
We aren't going to do that.
Right. I can see how that was a mistake.
God.
I understand. Look, I need to do some more thinking on this first issue, but Bottom line is we are going to get you all some help.
We appreciate you. We really do.
I love this scene. Yeah, right. Get the hell out of here. All right, enough. So if you couldn't hear, I know the audio wasn't ideal. The lawyer was like, "We need to get your case into federal court, and the quickest way to get your case to federal court is for you guys to get arrested." So he wanted them to go back to Virginia, go be there together, and get arrested by the state. He's, "Oh, bail you out." I think you should have watched the video clip for this one. They were held in a jail cell, or at least Ruth was. He was given bail, but Ruth was held in a jail cell for the entire weekend. She was pregnant. They arrested them deliberately on a Friday, so they wouldn't get bail till Monday morning. It was quite awful. They arrested them in the dark of night. So, there was no way in hell they were going to get arrested. But they found a way to get back into court by trying to set aside their conviction. But go watch this movie. Most Supreme Court movies are actually pretty bad. This one I thought was excellent. I really thought it was well done. It really captured the case well. Okay, so they're able to get their case to the Supreme Court, and it goes up. And if you have a few minutes, just pull up the oral argument for this case. I included, in the video a few minutes here and there of the argument, but just listen to the entire thing. It's been, how long is it? It's about 2 hours long. So if you have some free time, I sent it to everyone. If you have 2 hours of free time and you want to listen to it, it's quite remarkable. Virginia had the burden of proof. And Virginia had to defend its suspect classification. And so they had to identify a compelling governmental interest. And their interest was not necessarily what you'd expect. The interest they asserted was protecting children. And here was the argument. I didn't realize this was their position until I actually went ahead and listened to the argument. I was like, wow, that just jumped out at me. They said that it's unfair to bring children into biracial homes because the children will be subject to racism and stigma. So in order to protect children from that form of prejudice, the state would simply prevent their parents from marrying. And you may say, well, Josh, who cares if they get married? They can have kids. At the time, it was a crime to have a child out of wedlock, right? You had to be married to have children. I'll use a phrase they use, legitimate children could not inherit property. They were attached to a lot of different stigmas. So the restriction who can get married was itself a restriction who could have children. And so the state said, we're not doing this because we're racist. We're trying to protect the kids, right? The way to protect them is to keep them separate, right? Not to have interracial children bring into this world. And when I heard it, I was like, wow, that's their argument. And just when you hear it, from the lawyer's mouth, it's like, oh my God. That's what you go to court with. And it's not surprising they lost 9-0. It was a unanimous decision. So the equal protection analysis in Loving, I think, was fairly straightforward. First off, the court says, your compelling interest is not really a compelling interest. This is not about protecting children. This is about promoting white supremacy. And indeed, the law that was passed here was passed in the same legislation as the Sterilization Act in Bakke v. Bell, right? The same legislation that created the Eugenics Act created the Interracial Marriage Ban. Right? It was the idea that we need to stop inferior people from breeding. We need to stop Carrie Buck from breeding. And we need to stop Mildred and Richard from breeding together. Right? It was the same concept that you have these inferior people and we need to rid them of the earth by stopping them from reproducing. Right? So the court says that there's no real legitimate interest here. And this is in no way narrowly tailored. Right? If you're actually interested in helping children, help the kids. Give them counseling, right? Give them, assistance. Try to stop bullying. Try to stop racism. Do other things. But this is such a overbroad remedy to accomplish what's really not an important or even a legitimate state interest. At bottom, this was designed to maintain supremacy. And this law flunks strict scrutiny. This is, I think, one of the easiest strict scrutiny cases of all semester. I mean, just the court applies it. It's very clean. It's very neat. Questions on the equal protection analysis in Loving? No? I'm sorry, Macy. I know you have no free time. I'm sorry. Believe it or not, some people actually do like this stuff. They actually enjoy listening to the arguments in the Supreme Court. If anyone's interested, tomorrow at, 9 Central, the court is hearing arguments in the new Obamacare case. It'll be on C-SPAN. I'll be listening. See what happens. All right. That's equal protection. There's also due process. There's also due process arguments. Okay? And the court's analysis here sort of intertwines due process and equal protection. They're sort of related. And the court says that marriage is a basic personal right, essential to the orderly pursuit of happiness. If this sounds familiar, it should. This comes from Meyer v. Nebraska, right? Justice, was it McReynolds, had this list of rights in Meyer. This was the case about the German teacher who was thrown in jail. Keep in mind, this is pure Lochnerism, right? To identify an unenumerated right. The equal protection component of Loving, I think, is consistent with footnote 4, right? Minorities, racial minorities, that's easy. But the due process analysis does not follow from footnote 4. There is no enumerated right to marriage in the Bill of Rights. It's a liberty protected by the 14th Amendment. So in the due process component of Loving, they just disregard footnote 4. Doesn't matter anymore. They had already ruled that the law is unconstitutional, but they kept going, and they put an additional holding on, and they reached this question about whether marriage is a fundamental right. And because marriage is a so-called fundamental right, under the due process clause, the law is reviewed with strict scrutiny. You see, with equal protection, there's a suspect classification, so you use strict scrutiny to review the law. And with the due process clause, there's a fundamental right, and you also use strict scrutiny to review the law. So you're using strict scrutiny in two different ways, with two different clauses to reach the same result. Okay. Questions? Yes, Tori, go ahead.
Just real quick, I think I'm having a problem with the classification of fundamental and non-fundamental right. Is it like it?
We'll discuss what that means later. Don't kill yourself over it now.
Okay, so it's not like enumerated and
yes.
Enumerated,
well,
a number or whatever it's called.
We'll get to penumbras later. But footnote 4, if you recall, said if there's a right that's in the first 8 amendments, you don't use presumption of constitutionality. That was paragraph 1, right? So that's all you need to know for now. This right of marriage is not in the first paragraph of footnote 4. It's not an enumerated right. So this is going back to Meyer v. Nebraska, which was a Lochner case. It was about substantive due process. Everything comes back to Lochner. No matter how far you go, you're in Lochner world. It's pathetic. But it's like the same. This is why, if you ever go to my office, I have a poster of Lochner's Bakery hanging over my shoulder in my office, which I'll never even go back to again. Who knows, right? But it's there, I promise. That makes sense, Tori?
Yes, it does. Thank you.
Yes, Macy, go ahead.
If by the 1970s, there's 2 cases that consider marriage a fundamental right, why does it take another 50 years for the court to address same-sex marriage?
Sure, happy to answer that. So, Macy, the court says that marriage is fundamental to our very existence and survival. Why is marriage fundamental to our existence and survival?
legitimate question?
Oh yeah, I'm asking it.
I mean, like, pursuit of happiness, you have to have children. Oh.
See, you didn't think of that one. No one thinks of that question, and I'm not trying to be critical of you or anyone else. People think of marriage as something you do for fun, right? Because you get pretty pictures for Instagram, right? It's something you enjoy. But historically, marriage had a very specific and limited purpose: to create homes for children. It's to responsibly procreate, right? That's why marriage existed. The idea was if you keep two people together, they're more likely to raise a healthy child than if they're apart. And, societies throughout the world, throughout recorded history, had marriage in every continent in the globe. Marriage was essential to existence because you needed to reproduce. Now, not every marriage could yield children. Some people, for health reasons, whatever, can't, and some people choose not to have children. That's fine. But the government can set a policy to promote child rearing by creating this institution of marriage, right? That's why marriage existed. It wasn't when people come together to be happy and in love. That's a fairly modern invention, right? Love and marriage is great, but it's about kids. That rationale does not apply, at least right away, to opposite same-sex couples. Indeed, in the 1970s, there was a challenge to a gay marriage. Well, there wasn't a gay marriage law, but there was a gay couple that sought to try and get a marriage license, and the Supreme Court said this is a ridiculous question. There's no question this is legal. We will discuss the gay marriage case at some length, and the court will move from this history where they sort of decouple marriage from raising children. And once you separate marriage from raising kids, then the gay marriage argument becomes a lot easier. But at least here, Mildred and Richard wanted to have a family. That's why they got married. In fact, I think Mildred was pregnant when they first got married the first go-around, and otherwise have a legitimate child. That's why marriage existed. Does that answer your question a little bit,
Okay.
Mason?
Yes, it does. Thank you.
Yeah, but people don't think about babies. They think, oh yeah, marriage is about love. No, it's not. That's cute, right? That's adorable. Marriage is about children. And that's why there was such a stigma on unmarried couples having kids, because they weren't doing it the right way. Okay. Questions on loving. Oh boy, I have 10 minutes left for affirmative action. Lainey, go ahead.
Rather than fight the good fight, if Virginia didn't want them, why didn't they just go be someplace where they could be happy and not have to fight with the government about it?
No, this was their home, though. That's where they wanted to be. That's where they were raised. That's where their family was. I mean, I imagine a law that says you can't go visit your family. They couldn't even drive to Virginia to see their loved ones. Sort of like New York is not letting me go see my... No, I'm joking. I have to be in quarantine for 2 weeks. No, it's actually a non-trivial issue. The sort of quarantine bans are actually restrictions on seeing family, and there's serious constitutional issues that are just not being discussed because of Skype. People don't care. But they want to be home with their family. I understand it. And I don't think it's an answer to say, if the government's violating your rights, you can just go exercise your rights somewhere else.
That's why I said they are fighting the good fight.
I mean,
I guess I'm just not a
yeah.
fighter. I left you, Virginia. I'll go be someplace else.
Yeah, I mean, just to use another example, if Mississippi bans abortions, why can't someone just fly to New York to get an abortion? Right, that's perhaps a modern example. You say, oh yeah, it's a good idea, Josh, right? Or, if California won't let me buy a gun, why can't I buy a gun in, Texas, and move to Texas if I want a gun? We say constitutional rights serve as a floor, right? You can't go beneath it. You can't go below that, right? So there's a minimum of what rights must be protected, and the government can't go below that. But there's always a federalist answer that if you don't like your state's policies, you can leave, you can move, which is not always easy for everyone. If I remember the Lovings case correctly, they moved to D.C. for some years, and their kid, was he hit by a car, or there was some sort of car accident that was involved because he was running around playing in the streets of D.C. And, they said, we have to go back to the country, to our farm. Oh yeah, courageous for sure, very brave. But, we generally say that people shouldn't have to leave their state to exercise their constitutional rights. Now, whether it's a right, of course, is a threshold question. Okay, thank you for that, Lainey. All right. All right. Questions on loving. I am not going to finish the affirmative action case today. I'll spill over till next class, but I'll at least start it. When I cover cases like Brown, when I do affirmative action, it's not so unanimous. This is an issue that continues to divide people. I'll give you a contemporary example from the last week. In the 1990s, I think 95 or 96, California enacted a ban on affirmative action, that schools cannot use racial preferences. By the way, they ignore it. They find different ways of doing it, so it's almost a meaningless law. But at least in practice, in theory at least, California can't engage in affirmative action, both in public schools and government contracting. Every couple of years, the legislature tries to repeal it, and there's never been enough support. Just this past Tuesday, we had an election last week. It was 6 days ago, if you can believe it. Just this past Tuesday, California had a ballot initiative. Yes, that would have repealed the ban on what's called Prop 209, this ban on affirmative action. And even in California, it did not get a majority. And the coalitions are fascinating. This is a liberal state. This is progressive. This is, very, very left of center place. And even among left of center people, this is a divisive issue. In certain segments, it was very popular. In other segments, it wasn't. This is an issue when people are divided. And I think it can be a difficult topic to discuss. But I give you that example, say this is not only, a right-left issue. Even within certain segments, there's disagreement over how it works. So what is affirmative action? Right? It's a phrase that derives from a very famous executive order from President Kennedy, which suggests that it's not enough to merely prohibit racial discrimination. That in some cases it's needed to do more than that, to take what's called affirmative action or maybe positive steps to include certain racial minorities in a government hiring program or some other policy. Today, affirmative action really takes root in two primary contexts, education and government contracting. I don't have time to cover the government contracting analysis. There's a case in your book, you're welcome to read it, called Adiran versus Pena. It's in your book, you can read it. I know you'll have lots of free time. But you can discuss how racial preferences are used for government contracting, for example. Can a government contractor set aside certain contracts for racial minorities, for businesses owned by racial minorities? I don't have time for that. The most significant context is in the context of education, both K through 12 and college and graduate. I will tell you, of all the issues in your book that are probably going to change soon, it's this one. I don't expect the case in this topic to look the same in 3 or 4 years. I think they're going to be totally different. Abortion, maybe, but given the current composition of the court and that, God willing, we're not going to 11, I think we're stuck at 9 for a while. No court packing, bad. For teaching purposes. I think the affirmative action cases are probably going to go. So what you're learning now is probably not going to be good law in a couple of years. You'll need to know how it changes, but this is an area in flux. Because it's an area in which the court's been bitterly divided for almost 40 or 50 years, and which now I think there's finally a solid majority of the court to reject the Bakke model, or at least limit the Bakke model. Okay. You know what? I don't even want to start Bakke with 5 minutes left. It's just not going to work. So we'll I'll ask for questions in a minute, but we'll pick up for class starting with Bakke on Wednesday, and then we'll do Bakke, we'll do the Michigan cases, and we'll do the Texas case. I think this is all in a single period. I don't want to start with 5 minutes left. Can't do justice to it. All right, questions on today's material? Questions? All right, I'm going to start the minute poll now. I'll be here for office hours around 12:30, and I'll see you all on Wednesday. Thank you so much.